Welcome to Judicial Dollars and Cents, brought to you by Anders Virtual CFO Services team from all across the United States. I'm John Scott, and in each episode, we'll shine a light on the financial side of the legal world, turning law firm numbers into impact-driven stories. From taxes and profitability to practice growth and leadership, we sit down with law firm innovators who are shaping the future of the profession. Let's dive in, right here on Judicial Dollars and Cents. Hey, welcome back to Judicial Dollars and Cents. This is the podcast where we dive into the business side of running a law firm. I'm John Scott with Anders Virtual CFO Services for law firms, and each week we talk to industry experts who help law firm leaders think differently about growth, profitability, and performance so they can build practices that last. Today we have Don McGarrah. Don is a nationally recognized trial attorney specializing in catastrophic personal injury, complex commercial litigation, and property subrogation. He has extensive experience in serving as lead trial counsel in 38 states, and he has successfully litigated and resolved numerous multi-million-dollar cases, earning industry recognition for excellence in trial advocacy and courtroom strategy. He is currently a partner at McGreedy, Garcia & Leet in the Chicagoland area, although it's an Illinois firm with multiple offices, and he plays a critical role in preparing and trying high-stake matters on local, regional, and national scale. Beyond litigation, we're going to find out about his illustrious rugby career, but he also advises manufacturers on risk mitigation and risk management. Don, welcome to the show.
Thank you, Scott, John. Thanks so much.
Thanks for coming on. Hey, I love to hear people's origin stories, and I'd like you to tell us yours.
All right. So I never thought I'd be in the law, although my father, who was a career Navy officer, always wanted to be a lawyer. I wanted to go into the entertainment business. So I majored in communications in college, but I studied a little bit about entry-level things and saw that it might provide a lot more leverage if I came in with a law degree or an MBA or a combination of all the above. I took the LSAT. I scored very high. I went to law school in St. Louis, but I started working for a trial firm while I was there. And so that led to a job in St. Louis, which led to an interview up here with Phil Corboy, who is regarded as one of the top trial lawyers in the United States. And I got a job offer and came up here, and everything else is history. I mean, I started, someone had advised me, if you're going to try trial work, you need to do that early on, because you're never going to go, from the corporate arena back into trial work. And so that's my story. And then I was fortunate enough to grow up with both my parents are gone, but my dad was a naval officer. We moved every 2 to 3 years. So I've lived all over the United States. I never thought I'd live in the Midwest because I grew up in Southern California, Monterey, where else? Mississippi on the Gulf Coast, the Norfolk, Virginia area. We lived there, and then Washington, D.C.
I'm sure
I'm here. I had a great experience.
I'm sure your dad was very pleased that you found a profession and not that entertainment stuff that he was worried about.
That's probably true. He was an engineer, but he always wanted to be a lawyer. So I'm honoring his legacy. Let's put it that way.
And you're so right about being in trial and it's almost like being on stage. You either get it or you don't.
Right.
And if you get that experience early, you can develop it. I have a daughter who is an attorney, and she is in trial quite a bit. And she has a similar background in that she never thought about going to law school. She wanted to work for a nonprofit. And I had a lawyer client who came up to her and said, "Now, Katie, you can either work in the nonprofit or you can go to law school and run the nonprofit." And I thought, boy, you're barking up the wrong tree here. There's no way she's going to law school. Well, she did. And now she works for a nonprofit law firm that helps people with tenants' rights. And so she has this same kind of backdoor into the legal profession as you did as well.
Great.
Hey, when you litigate these big cases, I assume that when a case comes in, you can evaluate it and determine its merit, right?
For the most part, yeah.
Can you talk about that process, how you evaluate it, assign a value to it?
Yeah, well, first of all, commercial cases you have to be very sensitive about because a lot of times there's no insurance coverage involved, and you've got to make sure that the defendants or the potential defendants have assets. In other words, you're going to be able to recover something. But in terms of, I'll just illustrate for you in terms of like a catastrophic med mal case. Those are cases that, one of the most expensive cases to prepare and try would be one, they're referred to as birth injury cases where a child suffers hypoxic ischemic encephalopathy from lack of oxygen during labor and delivery. You could have up to 6 or 7 different types of experts. By the time you get to trial, you can have 200 to 300 grand into the case, and that's over a 2 to 3 year period of time. So you have to be very, very careful, particularly from a plaintiff standpoint, that you're going to be able to make a recovery. There's no guarantee, but you have to do your homework. So we get all of the imaging studies, all of the records. I do an initial assessment because there's a lot of these things where I've been doing this for so many years, and I've done it for both plaintiffs and defendants, but there's certain cases that we will automatically not take as a plaintiff for a variety of reasons. But if it passes that test, then I'll typically send it out to one of our OB nurse consultants to confirm my inclination that, there's something there. And if I get a thumbs up there, then we send it to a board certified OB or maternal fetal medicine specialist. And once it passes all of these milestones, not only in the standpoint, from standpoint of liability, but on causation, which is extremely important, then we get at it, because that is a very expensive proposition, both in terms of time and money. The upside is, if you recover for someone under those circumstances, it's usually a very significant recovery, but you've got to be very aware of all the issues. The defense is it's easier to get very good experts on behalf of a defendant than a plaintiff because a lot of the doctors don't want to testify against colleagues, number one, and number two, some get direct and indirect pressure not to do that in a variety of ways. But that's an example of where you have to be very careful.
Well, the reason I ask, and somebody with your experience is going to be very selective and know how to make good risk decisions.
Right.
But when we come into a PI firm, we want to be able to forecast revenue. And what we do is we look at the inventory of cases they have, ask them about the expected values, and then the different milestones within the cases. Now, your cases have a much longer defined period. It's not like a motor vehicle accident where I send out a demand letter and we can resolve this in 6 to 9 months.
Right.
Yours are going to be more extended, but we can build a forecast with that and help you predict cash flows. And that's why I kind of wanted to know the process that you go through in designing that. So let's switch gears a little bit and let's talk about, you've got that litigation experience for so many years and you got it early on, but how do you prepare mentally and strategically to go into litigation and prevail?
Well, first of all, I've had very, very good training from some very, very good people. But one of the things that I talk to young lawyers about is you need to start figuring out what you're going to say about your case the day that it walks in the door. There is certain, it's not a situation where I'm just going to get evidence and react to it and manage it. It's going to be a situation where I'm going to look for the evidence, and as I prepare the case, I'm going to understand the evidence so that by the time we get to trial, I will have already I've already mapped out all the key issues. I've mapped out if I'm representing the plaintiff, which is what I do now, I know pretty much what I call the anchor points in the case and the theme. And I want to talk about, primacy and recency in terms of the theme and anchor points. And because when you make an opening statement, you want to tell the jury what you're about to say. You give them the body of your remarks and you tell them what you just did say. And that goes back to that communication algorithm. But, and I also do whatever I can to anticipate every single defense. so that, and the assumption I make and our team here makes is when we're going into trial, we want to assume that we're going up against the best trial lawyer or lawyers that you can face under these circumstances. You plan accordingly so that if you run into, anticipated issues and someone on the other side starting to score points, you're not going to be surprised. You're going to be ready for it. That doesn't mean you can overcome everything, but at least you're prepared. And this is a tough business. I've seen a lot of very good lawyers, particularly very busy lawyers at a senior level. If they don't have a good team around them, sometimes they're not prepared for every eventuality. I'll pronounce that word improperly, but they're prepared for every circumstance that can arise. And not because they're not smart, not because they're not experienced, they just don't have the time. So that's why it's absolutely essential to have a good team. And all of those things go into this. And at the very highest level, we use mock trials as well from time to time. And you bring in people from the same community. And a lot of times in those cases, I'll bring in one of my partners to be, and a lot of times in those cases, I'll play the part of the defense lawyer. And I will test out defenses that I think will be effective. And I'll attack things that I think our team has a lot to talk about just to see how people react to it. So it's a combination of all of those things. The more money and the more complex you get, you've just got to keep it moving in the right direction. As we prepare cases here, our team, we have what I call a trial preparation memorandum. And you start off with the basic facts. But as the case gets prepared, we add witnesses, the source of the witnesses, the key aspect of their testimony. We add exhibits. So by the time we get to trial, we've got a document, and it's got everything there. That doesn't mean that we take that document and then we put together, like I said, themes, anchor points, and I want to be able to articulate a proposition that's direct, clear, and easy to understand. And then with anchor points and themes, you do those over and over and over again. So if it's a breach of contract case, it's not a breach of contract case. It's a broken promise. By the time that case is done, let's say it's a 2-week trial, the jury will have heard that's a broken promise probably 100 times. That's just part of the key theme.
So because of this preparation process, you're never going to have that deer in the headlights look. You may not be able to overcome the issue, but you've expected it, anticipated it. And I want to focus on something you said early on. You do plaintiff work now. Sounds like you've done defense work in the past. And I think that's probably helpful in that you know how the other side works. And some of your best criminal defense attorneys have been prosecutors prior to being a defense attorney.
Absolutely. You don't have to go through that, but I've lived it, and I've lived at a very high level, very complex cases on both sides of the street. And I tell you, for instance, here in Chicago, we've got an excellent defense bar. And so whether or not you're talking about commercial litigation, product liability, or complex med mal cases, we've got some great trial lawyers here in the defense bar. So it's a great place to practice because you're going up against some very, very good people. And you learn a lot and you prepare your cases accordingly. That's how you become a good lawyer. So,
hey, so you advise manufacturers and companies on product liability issues. If we could apply that to business leaders and leaders in your own firm or leaders you've seen, what should leaders be thinking about to minimize risk and have a successful firm?
Well, I mean, the devil's in the details is what I say. In the product liability arena, one of the themes that we developed, and again, when I say we, I'm talking about our team, not here, but at the Wildman firm where I did a lot of this, was to become thoroughly familiar with every aspect, operational aspect of that product from A to Z. And so from the standpoint of risk, and since we were doing that on a national basis, most of these companies had their insurance program set up so that they had a large SIR, which is a self-insured retention, that gave them control over the litigation. So we were dealing directly with the C-suite executives and the board. And so we applied the same methodology. We went in with a team, we retained great experts. We had great investigative resources. We had retired FBI agents that we used as investigators, so that when one of these cases was filed, we had someone, and we heard about it, or we were served with a complaint. We had one of our investigative people down there within a matter of a day or two, and we pretty much knew in short order what happened and why. And I'm not talking about doing anything inappropriate. These guys were very, very good in terms of their investigative techniques. They would go in and establish rapport with the local police chief, or whoever investigated the accident. They knew the investigative algorithm, and they knew everything there was to know about the product. So what I would say to the business leaders, you need to be absolutely familiar, thoroughly understand every aspect of your operational construct in your company. If you can do that, then you can identify areas of potential risk, and then you engage in what is referred to as risk prevention. And certainly when risk arises, you want to mitigate it and manage it, but if at all possible, you want to prevent it. So, just as an example, one of the areas of risk that any company has to be cognizant of is, let's say you have a board of directors meeting, and someone prepares some addition to the minutes. It's kind of tongue-in-cheek or comedic, but it is not, shouldn't be in there for litigation purposes. People laugh about that, but I have seen and then had to be asked to manage issues in minutes for the board of directors meetings that could turn into multi-million-dollar losses. And that's not because, and these are smart people. They're just not focused on that.
But we have so many ways to communicate internally. All that's discoverable, whether it's email, Slack, Signal, text messages, and people, they might say things that they think will never be seen again, but they are discoverable.
Right. I agree 100%. And that's the other thing is when we counsel people or have that, I tell people you have to assume that your communications at some point are going to be reviewed, in a litigation or claims or also in a governmental, investigation or administrative aspect. And that's something that as a business leader, I want to be very familiar with. I don't want a governmental agency coming in here and finding something that may have been, off the cuff or tongue in cheek, and then they decided to fine my company a couple of $1 million. Those are classic situations that can be avoided.
So you have a lot of non-attorneys on staff, nurses, people help you evaluate evidence and depositions. Do you see any use for AI, not to replace what those people are doing, but to make them more efficient so they can focus on the real meat of the issue rather than the busy work?
We've been using AI every day since it came out. This firm is extremely involved, I should say. I was going to use the word aggressive, but I don't know if aggressive applies. We use AI in a lot of circumstances. There's firms out there right now that specialize in AI. You can use an AI algorithm to take, let's say, the last 3 or 4 closing arguments that I've made. You plug all that stuff in, then you plug in the facts, and then all of a sudden, boom, they start coming out with some key phrases. Now, I'm too much of I come from a family of engineers and type AAA, so I'm too much of a control freak to rely on that, but I use it as a tool. And then we use it as tools in terms of identifying key information in depositions. And then a lot of these meetings where I'd be sitting here, on a computer while I'm talking to someone taking notes. I'm not doing that anymore. AI is recording that, and they spit out a summary to me. So we're looking at every aspect of how we can augment what we do here, not replace it, but it makes things more efficient. And as you know, the business that you're in, the more efficient we can be, the more money we can put on our bottom line. And if we're inefficient, we may have a hard time staying in business. And I've seen actually some very good firms, smaller firms, go out of business because they undertake a couple of large cases and they don't have enough revenue producing sources. And then all of a sudden you get underwater, then boom, you're done.
Right. You can't wait for the payday because you've got to pay your bills along the way.
Absolutely.
And I love your approach to AI and your firm's approach because it can create those efficiencies in the routine task, but then it needs that human oversight and element to evaluate its output. You can't just rely on it 100%. But I do think we're on the next wave of a revolution. In the accounting world, we used to do everything by hand, whether it was an amortization schedule or a depreciation schedule. And then we got, VisiCalc and Lotus 123, and now we have Google and Power BI. This is just that next wave that's going to help create some level of efficiency. And I think it's important not only that we ethically use it and have the human oversight, but that we don't look at the capacity it creates and say to our folks, oh, well, we can do more. What we need to do is say, take that extra time and do higher level things. And then also go spend time with your family. Go enjoy your life so you can have that work-life balance. AI should help us and not hurt us. And I think there's two camps in the attorney world and in other professions. The camp that says, oh my gosh, it's the death knell of the profession. It's going to be the ruination of us. Or there's the camp that embraces it. And some of those smaller and mid-sized firms can compete with much larger organizations because of their use of AI.
Yeah, it is. It is a tool. The way we're looking at it, it is a tool. So I think that if you use that in that fashion, then it can help every aspect of your business, number one, and your bottom line. And I agree with you 100% in terms of reducing or helping work-life balance, because these are, we're both in a very difficult profession if we allow it to take over our lives.
So I think I mentioned maybe before the call that I have 4 children. They're all completely different, but 2 of them, their frontal lobe didn't quite develop quick enough, and they played rugby in high school, and one of them played in college. I understand that you played rugby. Could you tell us about that a little bit?
Yeah, I started to play rugby as a freshman in college. I didn't even know what it was. And I went to a small Jesuit school down south. I went out, I saw the game. I played football, for 8 years before that in terms of elementary school, middle school, and high school. And so one of my friends was playing, and I started playing. So I played for 12 years. I've got an artificial hip. I had a 2-level discectomy and fusion. I played for 2 teams in St. Louis. I played for 1 team up here. It was a very, very good team, Chicago Lions. I played in the Norfolk area I played with the SEALs, Navy SEALs, because I lived on a Navy base. My father was stationed there. And then I played for a local team there as well called the Norfolk Rugby Club, which was a great club. And then I played in the summers, for other teams. And we played in DC, one summer up in DC. I just went out and joined up with one firm. So it's a fun sport. If you play it at a high level, you've got to be very fit. And so and the fun thing is at the end of the game, most of the time they have a party. So the people you've been knocking heads with, you go in and have a few drinks afterwards and sing songs. In the old days, I don't know if they do that anymore.
Well, they do.
And, yeah. Okay. But I mean, that's that. And if you play it the way some of the people play it in New Zealand and South Africa and in Europe, where you tackle without trying to tackle like the old American, like you had a helmet on, you can reduce the risk of injury, but you don't eliminate it. And we had a guy in college, and I just saw him. I hadn't seen him in years. I saw him a couple of months ago. His nickname was Tiny, he would invariably try to tackle with his forehead, and he'd split his head every year. So he ended up with stitches. But I've had some very good experiences, and including the best conditioned athletes I ever played with were the SEALs.
Oh, I'm sure.
Those people would get up in the morning. Their day started at 5 in the morning. They would get up and work out for 2 or 3 hours. They would do a simulated exercise, or they would be training for a real exercise somewhere in the world, and their days were done at 2. So that they had to be on standby 24/7. When something happened, they put them on an airplane, they sent them off, and they pursued their mission.
Yeah, the rugby community has a great camaraderie, and you're right. After the game, the two teams get together. They do still sing songs, and one other thing I want to agree with you. I think a lot of football players should play rugby because it does teach you to tackle with your head to the side, no helmet. Some people wear little pads, but on their head. But if you tackle properly, there would be less head injuries and concussions in football.
Right.
Yeah.
Yeah, we had when I started playing in college, we had a gentleman who was from Wales, and he was teaching people how to wrap your body around someone's lower body as opposed to trying to hit them, like American football. And there's hitting, but I mean, it's not. You don't have the same protection, so you have to be very, very careful. So,
hey Don, this has been great. Before we wrap up, if folks want to get a hold of you, how can they get in touch with you or your firm?
Well, I mean, we've got a website. All you have to do is Google McCready Law. My email is very, very easy, donald@mccreadylaw.com. And I always give people my cell phone, which is 630-817-1503, 630-817-1503, and they can text or call me anytime.
Thank you so much. And thank you all for tuning in to Judicial Dollars and Cents. If you enjoyed today's episode, be sure to like, follow, and subscribe wherever you listen to podcasts. It helps us grow and ensures you never miss an episode. We'll see you next time on Judicial Dollars and Cents. Thanks for joining us on Judicial Dollars and Cents, presented by Anders Virtual CFO Services. If you found value in today's conversation, be sure to follow or subscribe wherever you get your podcast. To learn more about how Anders helps law firms strengthen their financial foundations and drive growth, visit anderscpa.com. Until next time, keep making smart decisions that make perfect sense.